Welcome to another edition of Question and Answer with a Criminal Defense Attorney. My name is Mark Solomon, a defense attorney in the Denver metropolitan area of Colorado. And today's question is about arrest warrants. So before we get going, don't forget, like the video if you're enjoying it, subscribe, and click the bell if you'd like to be notified of future videos. So let's get to the question. I have an arrest warrant. What can I do? Somehow you found out that there's an arrest warrant and you'd like to figure out your next choices. Basically, you have four. I'll talk about no bonds in a minute, but the three options that you have, you can either go to walk-in court, you can turn yourself in to post a bond, or you can do a walk-through bond or just wait to be arrested. So let's talk about that. When you do the first option, which is walking into court, hopefully with an attorney, what will happen is the judge may hear the case, but the judge just may take you into custody, and then you're back to square one as though you've just been arrested. The second option is you can do a turn-in, which is where you turn yourself into the detention facility and deal with your bond that way. Either you can post it as soon as they're done with the booking procedure. If it's a no bond, though, you'll have to go in front of the court the next day. And again, I'm going to come back to that in a minute. The third option is a walk-through bond. A couple jurisdictions in Colorado that I know of do walk-through bonds. You coordinate with your bondsman, you go into custody with the bondsman, they do the bond paperwork with your co-signer, and you're essentially out of custody in a handful of hours, 2 to 4 hours, you're in and out. Usually you do those in the evening, so it's the least impactful in your schedule for the rest of your life. And then what happens next is you walk out of custody with a court date, so you go to court next. The fourth option is always just wait to be arrested, but that that could happen at the least opportune time, and then you have to coordinate all the bond issues from inside jail, which is not as conducive to getting out as quickly or as easily. Okay, so let me talk a little bit about no bond. In every single felony case in Denver or any domestic violence case, a number of sex-type crimes, a judge will issue an arrest warrant with no bond, which means that you have to go in front of a judge before you can be released. And that means that it's listed no bond, you get taken into custody, booked, taken in front of the judge, and then you can make a bond argument. And at that point, bondsmen can come in and do their work to get you out. Okay, so quick note on Denver, just reminded me, we cannot look for outstanding warrants in Denver. For some reason, Denver, both county and district and general sessions, they don't post their warrants. So there's no way we can look for a warrant in a case that doesn't already exist. So if you haven't been to court, there's no way to know if there's an arrest warrant unless the detective is talking to your attorney or somebody standing in front of you saying you're under arrest. And either way, that's not good. Okay, so that is the question and answer for today. If you would like to submit your own question, put it in the comments below. You can email it to me at mark@solomonesq.com or tag me on Twitter with your question. Remember, in all of those, don't put any personal details about your case, anything that might be used against you. That would be bad. And speaking of that, remember, if a police officer talks to you about anything that you have done, been possessed, been with, anything like that, your best answer is always, I do not want to talk to you, followed up with, I want a lawyer. And with that, thanks for joining us today, and as always, have a good day and stay safe.